This is a public service.
We have two panels today. The first panel is the Circuit Court nominee, and the second panel will be the District Court nominees. Judge Kidd, if you please approach the table. Remain standing for a moment. Raise your right hand. Do you affirm the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect that the nominee has answered in the affirmative. You now have an opportunity to make an opening statement. Please proceed.
Thank you, Chair Durbin, for your kind introduction, and to all of the other senators on this committee for your time today. Thank you to President Biden for nominating me for a judgeship on the 11th Circuit, which covers the state where I grew up, Alabama, the state where I spent my formative college years, Georgia, and the state where I now reside, Florida. And it is truly an honor to be considered for a seat that is currently held by Judge Charles Wilson and was previously held by Judge Joseph Hatchett. I am happy to be joined today by several of my family members, my wife, Nominee Holmes Kidd, who has been both my biggest advocate and source of inspiration for the past 20 years. I certainly would not be here without her encouragement and support. We brought our 5-year-old son. I promised him that he would also have an opportunity to ask me questions today, but we'll do that later, maybe over ice cream. My father, Robert, joins us from Vincent, Alabama, which is a small town where my family has lived for generations. My father and my late mother, Mary Ellen Kidd, first instilled in me the importance of public and community service. My father served on the town council for 20 years, and my cousin Bridget Smith, who is with us today, succeeded him in that role and continues to be a shining example of servant leadership in the community. Those values of civic and community service are shared by my wife's family, and I'm happy to be joined by my father-in-law, the Reverend Dr. R.B. Holmes Jr., who is a long-standing religious and community leader in the state of Florida and nationally. His guidance and support have been invaluable to me over the years. My mother-in-law, Yvonne Baker, is a former educator and church leader, and I'm happy to have her here as well. In addition to my family, I'm joined by mentors and friends from various stages in my life, each of whom has contributed in some important way to my being here today. And I know that I have even more friends and family watching from around the country. I thank all of them for their continued support. And finally, I would like to thank my court family in the Middle District of Florida for their support, and particularly my career clerk, Robin Nauman, who joins us today, my current and former term clerks, Janelle, Alana, Shantae, Anusha, and Alexia, and my courtroom deputy, Julie. I thank them for their hard work and dedication to our shared mission. Senators, I welcome your questions. Thank you.
Thank you, Judge Kidd. For those who are here with the nominees and have not been through this process before, it is an interesting exercise. Men and women come before us hoping for lifetime appointments to the federal bench. They are questioned about their backgrounds, their competence, their integrity, and their record under the law. Judge Kidd, you bring one of the most lengthy records I can recall, 13,700 decisions. Amazing. Reversed 9 times. 9 times out of 13,700. That's quite a record. The American Bar Association asked lawyers and professionals in your community what they thought of your performance as a judge, and let me read what they said. The Standing Committee of the American Bar Association has the unanimous opinion that Magistrate Judge Kidd is well qualified to serve on the U.S. Court of Appeals for the 11th Circuit. That's a good starting point. Having said that, expect that at least 2 or 3 of the decisions which you reach will be very controversial and raised in this committee. That is part of the process. I know you're prepared for that. So let's start in with the question, if I can, in terms of 2 cases. U.S. versus Dady. Do you recall that case?
Yes, Senator.
Explain to me what your ruling was in that case.
In United States versus Deity, I saw the defendant at an initial appearance, and at that case, it was at that time it was on a criminal complaint, and my involvement in the case was really that initial appearance and a detention hearing, at which time, at the initial complaint stage, he had been charged with one count of possession of child pornography. After hearing that evidence from the government, I placed the defendant on home detention, house arrest. So he couldn't leave his residence without court's permission. He was on GPS monitoring, no contact with the victims or with any other minors. And subsequent to that, the defendant was indicted with 2 additional charges of enticement of a minor for 2 different victims. The government sought a review of that decision with the district court and presented additional evidence to the district court that was not before me, and the district court decided to detain the defendant, and then I think he was ultimately convicted of those crimes.
So your home confinement for pretrial was under charges that changed dramatically after. Is that correct?
That's correct, Senator. In addition, at the time that I saw the defendant, there was no statutory presumption that he should be detained based on the charges that he was ultimately indicted for. At the time that the district judge saw the defendant, there was a statutory presumption that he should be detained.
U.S. versus King. Could you explain your decision in that case?
In United States versus King, the defendant, I believe, had been charged with possession of child pornography. At the detention hearing, after hearing evidence from the government and hearing argument from both sides, this was another individual that I placed on house arrest with similar conditions, could not leave the residence without court permission. He was on GPS monitoring. He could have no contact with the victims or with any other minors. And in that case, the government, again, presented additional evidence to the district judge. And the district judge noted on the record that that additional evidence persuaded her that the defendant should be detained. And he was ultimately, I believe he was ultimately convicted of those charges.
So the charges against this defendant, after you initially put the home confinement requirement, changed and were increased in the district court, made a decision based on those new charges. Is that correct?
Senator, I believe in that case there was an indictment. I'm not sure if there was a superseding indictment afterward, but the government presented additional information to the district judge based on my review of the transcript regarding the defendant's compulsions, and that caused the district judge great concern. That information was not presented to me.
I'd like to ask you, in the minute remaining, if you can, to summarize your involvement in the Joel Greenberg case.
In the Joel Greenberg case, I was not the magistrate judge assigned to the ultimate case, but I was the magistrate judge who saw Mr. Greenberg at his initial appearance, and I set his conditions of release. At some point, Mr. Greenberg violated the conditions of his release, and I ordered him detained based on that violation.
Thank you. Senator Lee.
Thank you, Mr. Chairman. Judge Kidd, do you believe that rape laws are laden with racial baggage?
Senator, I have never made that statement, and as a former prosecutor, I prosecuted individuals who had committed crimes against children and other sexually violent crimes.
Okay. The reason I raised the question is that you're cited in the acknowledgments, very early in the acknowledgments, in a law review article written by Monica Bell, in which she thanks you for conversations that shaped the article. In this article, she makes a number of claims, including the suggestion repeatedly that rape laws, child rape laws, including rape laws generally as well, are laden with racial baggage. She also makes the case that the image of the child molester or the rapist is often disproportionately or unfairly leveled, this sort of racial dog whistle, and makes a lot of these cases after thanking you for conversations that shaped it. Are you saying you disagree with her characterization of the law in that respect?
Senator, I think I recall the article that you're talking about, and I believe that Monica Bell, who's my law school classmate, wrote that article while we were in law school, and I certainly have not made any statements, and I don't recall making any statements to now Professor Bell regarding any rape laws, so I do not adopt anything that she has stated. I'm certain we had conversations generally in law school. I don't recall what they were about, but I certainly do not recall any conversations about rape laws.
Do you share those views that she expressed?
Senator, as best as I can recall your summary, I do not share the views. I would certainly follow whatever laws are in place with regard to rape and whatever issue happens to be at issue.
All right, in the same article, she also stated, quote, when a law threatens to impinge on constitutional rights, and especially where those at risk are those whom society would most like to cast out or even exterminate, courts must understand and evaluate the social forces that motivated these laws. Today, child molestation sparks the same urge for community isolation and the spirit of vigilantism that rape did in the Coker era. An analysis of the multi-layered political context of capital child rape laws suggests that the social forces surrounding the new legislation are inescapably too intense, too frenzied, too emotional, and too mired in racial and class-based prejudice to avoid arbitrariness and caprice. Now, I'm not quite sure what she means by laws that implicate constitutional rights. In a sense, all criminal laws do that, in that they will restrain your liberty if you violate them and you're found guilty. She's arguing, in essence, that evaluating criminal statutes that implicate constitutional rights in one way or another, that in doing that, courts have to understand and evaluate these social forces that animate whatever it is that prompted the enactment of the legislation to begin with. Do you agree with that statement? And what bearing should that have? When and under what circumstances is it appropriate for a federal judge to consider what forces animated the enactment of a statute, for example, prohibiting rape?
Senator, I do not agree with that statement. As a sitting judge, and if I'm confirmed to the 11th Circuit, I would follow the law, and I would follow Supreme Court precedent, the 11th Circuit precedent. It's not my job as a judge to assess societal forces. That's left to the policymakers, not to me.
Are there any circumstances under which the social forces that motivated the enactment of a statute under consideration by the court should be taken into account? If so, what would those circumstances be?
Senator, I know that there are certain circumstances, for instance, with religious liberty, where if there is a law in terms of assessing whether it's actually generally applicable and neutral, the courts can look to certain circumstances surrounding its enactment. But as a general matter, no senator would not look outside of the plain text of the law.
So outside the narrow context of City of Hialeah versus Church of the Lukumi Babaluai, you would say you typically would not do that as a federal judge?
That's correct.
Great. Thank you.
Thank you. Senator Hirono.
Thank you, Mr. Chairman. Welcome to the nominee and to your family. I asked the following two questions initially to ascertain the fitness to serve of all of the nominees who come before any of the committees on which I sit. So, Judge Kidd, I ask you, since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No, Senator.
Have you ever faced discipline or entered into a settlement relating to this kind of conduct?
No, Senator.
Judge Kidd, the article that my colleague just questioned you, quoted to you, is from 2007. Does that article have anything to do with your role as a judge or how you would rule as a judge if confirmed?
No, Senator, and I barely remembered that I was mentioned in that article. As I said, we were in law school at the time, and I do know that my classmate published the article. But in terms of any statements therein, they would certainly not affect my consideration as a judge.
Could you repeat how you would decide cases before you?
Senator, I, as a sitting judge, and if I'm nominated to the 11th Circuit, I would approach each case with an open mind. I would consider the issues that are presented from each side fairly. I would thoroughly research those issues, and I would issue a decision that I hope could be understood by the parties involved and the general public, and I would treat the parties with respect.
That is my expectation of judges, that they be fair and objective, apply the law to the facts, and follow relevant precedent. Judge Kidd, as a federal prosecutor and then as a judge, you could not engage in pro bono representation, but you continue to give back to your community by speaking at local schools and volunteering with Bar Association programs. At these engagements, do you focus on a particular message or messages?
No, Senator. At those engagements, I'm mostly explaining the role of the judiciary, explaining the role of a judge. At some of them, there are law students who might be interested in appearing in federal court. I explain federal court to them. Some people are interested in becoming a judge, and I try to shed some light on that process as well. It's really my, I believe that it's my obligation, in a sense, to go out into the community and to provide that sort of education and to be that sort of role model for people who are interested in becoming a judge or a prosecutor or a lawyer.
I note that you have connections to all 3 states in the 11th Circuit. You were born in Alabama, went to college in Georgia, and now live and work in Florida. How has your background prepared you to serve the people who live in the 11th Circuit as an appellate judge?
That's correct, Senator. I have ties to all 3 states, and I'm proud of that. The 11th Circuit is my home circuit, and I believe that each stage of my career has helped me in the preparation for this position. In each job that I've had, I've been a generalist, so if I'm confirmed to the 11th Circuit, I will continue to be a generalist and delving into those issues that are filed in federal court. As a current magistrate judge, I'm assigned to every type of case that gets filed in federal court, and we're one of the largest districts in the country, so we see a lot. So I'm involved in helping the parties as they develop the factual record. We're often referred motions for summary judgment, so I apply the law to the facts as they set forth. We have a large Social Security docket in which we hear appeals from the Social Security Administration, which is the same standard that the 11th Circuit considers. So I think that my career to this point has prepared me for this position.
As a federal prosecutor, you earned the FBI Director's Award for your investigation of a drug trafficking ring in Central Florida. Can you briefly tell the committee about that case and your work on it in the time remaining?
Yes, Senator. I worked with the Federal Bureau of Investigation to investigate a local organization that was committing a number of crimes in Seminole County, which is in Central Florida. And through working with the FBI, we were able to obtain court-ordered wiretaps to infiltrate the organization, and ultimately several individuals were charged in a conspiracy and were ultimately convicted, making what we view as a very positive impact on that community.
And for this, you received recognition for your work, so.
That's correct.
Good job. Congratulations. Thank you, Mr. Chairman.
Thank you, Senator. Senator Kennedy.
Thank you, Mr. Chairman. Congratulations, Judge. I just want to talk a little bit about the law. Tell me about the war powers clauses in Articles 1 and 2.
Well, Senator, my understanding of the war powers is that the executive maintains significant authority with regard to the war, but that it has to be authorized by Congress.
What do you mean authorized?
Senator, I don't have a more, that issue has not come before me,
Sure.
But I don't have a more specific definition of authorization than that the Congress has to, it's up to the Congress to, to authorize it. I can't say more than that, Senator.
Okay. All right, let's talk about another issue you'll see if you're confirmed with the 11th Circuit. It's an issue we struggle with every day, and as do the federal courts. Tell me about the non-delegation doctrine.
My understanding, Senator, of the non-delegation doctrine is that Congress should not delegate its powers to other branches of government except in certain limited circumstances.
And what are those limited circumstances?
I believe, based on my understanding, that Congress can, for instance, delegate some of its authority to the executive, such as executive agencies, if that authority is carefully circumscribed.
I'm not following you. The Constitution's pretty clear in Article 1 that the legislative power resides in the United States Congress, and we can't give it away. But your argument is that we can.
Senator, it's my understanding that in certain limited circumstances that are carefully circumscribed, that Congress can delegate some of its authority to.
Okay. What's the guiding principle, though? If we tomorrow, if Congress passed a law and said we're no longer going to confirm judges, we're going to set up a special agency within the executive branch and give that agency the authority to confirm judges. Somebody's going to litigate it. What would be the principle that the court would follow?
Senator, I would certainly, if that issue were to come before me on the 11th Circuit, if I'm fortunate to be confirmed, I would research the Supreme Court's precedent and guidance on that issue and any binding 11th Circuit precedent on the issue, if there is any, and address that issue. But in terms of the hypothetical situation, Senator, I would leave it at that.
Okay. Well, let me ask you this. Let's set aside what the principle is for a moment. The Supreme Court has been pretty clear what the principle is. It goes back, 80 years. But let's suppose, well, strike that. What I'm trying to understand is how you think, Judge. What do you think the principle ought to be? I mean, our founders were very clear that the legislative power is ours, and clearly we've given away that legislative power in some instances to some administrative agencies. What do you think the principle ought to be? Could the Congress just come in one week and said, we're tired, let's just give it all to the president for about 6 months while we go fishing? Would that be constitutional?
Well, certainly, Senator, I think to that extent would unlikely be constitutional based on...
Why do you think?
Based on the principle that I just stated, that and that you have reiterated, that...
Which is?
That Congress cannot delegate its authority except in certain circumstances.
And those are?
And those are ones that, Senator, I would not want to speculate about. I can say that I would follow the Supreme Court's guidance on that, and my understanding of that guidance is that those circumstances are very narrow.
Okay. But you're not familiar with the principle?
Senator, to the extent that you're looking for a specific articulation,
Yes,
I would have to look at the case law and follow up
Okay.
on that.
Robert, do you have any questions you want me to ask your dad? You sure? Now's your shot, man. Do you have anything you'd like to say to us, Robert? It's okay. A wise man
I
once
think
said
you had a
nothing.
hello. I think you had a hello for
A
you.
wise man once said nothing. Thank you, Judge.
Senator Butler.
Thank you, Mr. Chair. Congratulations, Judge, on your nomination. Thank you to your family for their support and sacrifice, and to your young son, who looks about as interested in this hearing as others. Thank you all for coming, and thank you for your service to this point. I am interested in probing a bit and understanding how you would think about the staffing of your court, and how some of the experiences that you submitted in your materials might inform that. To that point, as a historically black college graduate myself, I note that you have spent some time at Florida A&M as an adjunct professor. Can you share with us the learnings, lessons offered to you by those sort of aspiring legal scholars, and how it would help you to think about the roles necessary and diversity necessary to be a part of your court?
Yes, Senator, thank you. I do have the privilege of serving as an adjunct professor at Florida A&M University College of Law, which, as you recognize, is a historically black college or university. It actually is directly across the street from the U.S. courthouse. So that was really part of my effort to help get those students who come, many of whom come from very non-traditional backgrounds, some economically disadvantaged backgrounds, into federal court. Because one thing that I noticed as a prosecutor in the court and then as a judge, that we didn't see the students very often. So I started the federal practice course. We would meet every week in my courtroom, and I would introduce them to federal judges and practitioners, and we'd have those conversations, which I think is important in terms of exposing those students and others to federal practice, which in some ways can be intimidating, and we often see people from a certain background. We don't see people very often who come from places like Florida A&M University, so I wanted to provide that exposure to the students, and it's really been a great learning experience, and it's impacted the way that I staff my chambers. For instance, I have conversations with students and potential clerks about clerking and why they haven't thought about clerking or applying to a clerkship, and one thing that I learned is that for many of them, should come as no surprise, they have a very heavy loan burden, and taking a year off instead of going to private practice but coming to clerk can present a financial challenge, but especially, which is common at the time I started, a 2-year clerkship. So that would be 2 years of that challenge. So now my standard is to do a 1-year clerkship that can be extended, but I think in that way I broaden the pool of applicants that I get for my clerkships.
I appreciate that. Just one last question, Mr. Chair, and I will yield my time. I meet you at a place of being from a small town. Birmingham is not small compared to Magnolia, Mississippi. But the states that are a part of the 11th District, 11th Circuit actually do encompass a variety of residents and geographical diversity, ensuring fair and adequate access to the law feels essential for a circuit that is so geographically diverse. Can you talk about how, from the experience that you have had as a magistrate judge, how it is that you approach ensuring fair, adequate, and competent justice, and so that litigants actually understand the positions that you are offering and conclusions that you're coming to?
Yes, Senator. And to clarify, I was born in Birmingham, but I was raised in Vincent, which has about 3,000 people. So we'll have to talk about who comes from the smaller town. But as a current judge, I take that issue very seriously because we have a lot of pro se individuals, and their case is very important to them as for any litigant, but they are often not well versed in the law. So I particularly take an interest in those, and I'll often bring them into the courtroom to try to explain the process for moving their case forward. And I've had some cases where the litigants were ultimately successful, and sometimes they just need a little help understanding how the process works. If I were to be confirmed to the 11th Circuit, I would continue to do that. I had the great fortune of clerking for Judge Gregory on the 4th Circuit, and he took a particular interest also in those sorts of pro se cases, the prisoner litigation, just giving them a closer look, making sure that their valid claims are actually heard by the court, and that's something that I would continue to do.
Thanks, Senator Butler. The senior senator from California, Senator Padilla.
Thank you. Well, I had a birthday a couple months ago. I'm just thinking, is that a jab? Thank you, Mr. Chair, and congratulations, Judge Kidd. You're going to be able to tell pretty easily that we are the two senators representing California because we both enjoy emphasizing the value of diversity in this committee and in our questions of nominees that come before us. So appreciate listening to the conversation I walked in on about the diverse perspectives that are important to have on the bench. Firm believer and cheerleader for diversity on the bench, not just because I think it improves the work product of the federal judiciary when there are people with a wide variety of both life and professional experiences that feed into the deliberations and the decisions. But in addition to that, I think as we're working to restore public confidence in the federal judiciary, we'll leave the Supreme Court alone here for a minute, but at all levels. And so coming into this process with that mindfulness, not just of what you and your potential service would represent, but I heard your mention about expanding the opportunities and access for clerkships, because you know how important clerkships can be for young attorneys as they're beginning their careers, whether it's in public service or in the private sector and beyond. So I heard a couple of the ideas that you mentioned. I don't know if there's any others of what you would do if you're fortunate enough to be confirmed to continue to broaden that reach and diversity for clerks in your courtroom.
Yes, Senator. So in addition to what I spoke about earlier, I do believe that there are things that we can do to improve the pipeline. Pipeline, I think, is part of the problem, the issue that can be addressed. So I have participated in several pipeline programs that are developed to address the pipeline. Such the Administrative Office of the Federal Courts had one a year or two ago about magistrate judges, and it was really to inform lawyers, law students about the process of becoming a magistrate judge, to kind of pull the curtain back a little bit on that process and to encourage people who might not otherwise think of themselves as someone who could be a magistrate judge to give that a second thought and provide resources for them and an opportunity to speak to current magistrate judges. So in that way, addressing school groups the same way, law schools especially, I think is another way to address that problem of just putting in there in law students' minds the idea that that is something that they want to do, so that then we then have a better pool of applicants to draw from.
Look, I I'm a big believer in those pipeline programs, as you call them, or outreach programs, as I understood them. I am not an attorney. I'm an engineer, and if it wasn't for those outreach programs when I was in high school, I don't think I would have thought of it or certainly achieved it. So there's a lot of value there. In the time remaining, I'm going to sort of flip the script a little bit on you. Because we've already talked about diversity and ideas on how to do better outreach here. So for those aspiring lawyers watching at home, for that young person, maybe a law student, maybe an undergrad, maybe a high school student, or even younger, with a little bit of an idea or a dream of maybe someday becoming a federal judge, share with us and share with them what inspired you to pursue this career path.
Thank you for that, Senator. I am not someone who grew up in a family of lawyers. I grew up in a working class family. It was a great family, but no lawyers in my family. So it's not something that I thought about when I was going through high school, or really even until about junior year of college, when I took a course on constitutional law, which I thought was really fascinating, and I developed a relationship with that professor. And then at that point, I decided to go to law school. So it was really that point that I decided that law was something that I was interested in. And in terms of being a judge, I would say my clerkship with Judge Gregory on the Fourth Circuit was instrumental in that. Again, I did not have judges in my family growing up, so seeing him and how he approached the law and the importance to him of being in the community and community service as a judge, and working with him behind the scenes in each case, that's what really inspired me to someday think that I myself might want to be a judge one day. So I would encourage anyone who has an inkling of going to law school to talk to people, develop those types of relationships with their professors, if they know any judges, and to, if they do decide to go to law school, give clerking a thought.
Oh, well, two great lessons today: the value of pipeline programs and the value of mentorship.
Absolutely.
Thank you. Thank you, Mr. Chair.
Thanks, Senator Padilla. Senator Blackburn, we'll give you a moment to compose yourself.
Thank you, Mr. Chairman. I appreciate that. Judge Kidd, I want to ask you about U.S. versus Rodriguez-Sanchez. You remember that case?
Senator, the name does not ring a bell, but perhaps
Okay.
the facts might.
All right, this was an illegal immigrant from Mexico, and you ordered him released from federal custody pending trial. And he had quite a criminal history. He had a series of charges, including resisting an officer with violence, 2 charges of domestic violence. He was deported by ICE in 2011, and then at some point, he illegally re-entered the country. Now, in deciding to release this illegal alien, you essentially determined that under the Bail Reform Act, he did not pose a danger to the community. Do you think that crimes of domestic violence are serious enough to impose a danger to the community?
To answer that question, Senator, yes, and I don't recall that specific case, but if this were an illegal reentry case, I would note that it's pretty rare that release is granted in those cases, so I imagine I also would have placed him on house arrest or
Well,
with GPS
he was
monitoring.
on an ICE detainer when you decided to release him. And another consideration for deciding whether to release a criminal defendant pending trial is if they pose a flight risk. And how could you possibly argue that an illegal alien with a criminal record was, and they were going to be deported by ICE, that they were not a flight risk?
Senator, in those cases, the question is whether there are any conditions that I could impose that would mitigate any risk of flight. And again, I don't recall that specific one, but generally, if it's...
Would you like to review that and then submit an answer to me in your questions? Because to me, when we're looking at crime that is committed by illegal entrants into this country, this is something that is of tremendous concern to me. Another one that is of concern to me is the article, and Senator Lee mentioned the article to you that deals with child rape laws. And I've done a lot of work working on children that are being trafficked. And the chairman's done a lot of work dealing with child sexual abuse and exploitative material. But the fact that you were listed as having had conversations that shaped an article about capital child rape laws is of concern to me. One of your statements, and I'm going to quote you on this, is that capital child rape statutes are formed at the nexus of three movements: the popular movement to shame, fear, and isolate sex offenders, the feminist movement for harsher punishment of sexual and intrafamilial violence, and the legal and political movement to punish attacks against vulnerable victims with death. So there's a lot in that. So do you think there is currently a popular movement to shame, fear, and isolate sex offenders?
Senator, that was not my statement.
That was not your statement. It's an article you contributed to, and that is the author stating, and I'm quoting that. That was it. So do you agree with that? Do you think that there is a popular movement to shame, to fear, to isolate sex offenders? Do you think sex offenders are criminals? Or do you see them as victims? Do you think that there is a feminist movement that is pushing for harsher penalties and punishments of sexual and intrafamilial violence?
Senator, as a former prosecutor, I prosecuted many cases involving sex offenses, and I believe that those offenses and those people who commit them should be punished.
Let me ask you this. Do you think it's wrong for the article to advocate for harsher punishments for sexual and intrafamilial incest violence?
Do I think that it's wrong to advocate for harsher
Right.
punishment? Senator, as to the particular policy considerations, I would leave to this body. But again, as a former prosecutor, I did seek significant punishments for those who engaged in those offenses.
Okay, why don't you pull your records and let us know how many conversations you had with the author that shaped the contents of the article. Thank you, Mr. Chairman.
Would you like to clarify that, Judge Kidd? Because I understand your name was mentioned in a footnote to an article which you didn't author, and that's why this line of questioning has arisen.
My understanding, Senator, is that I was listed in the acknowledgement somewhere in the article that was written by my law school classmate. I did not write anything in the article, and I don't adopt any statements in the article. Quite frankly, it's been so long, I don't remember what the article was about, aside from what the senators have summarized today.
Well, perhaps for Senator Blackburn and others, you can put that in writing, clarifying your involvement in that. Is that all right, Senator? Judge Kidd, thank you for joining us. There may be written questions submitted by other members of the committee, which we hope you'll respond to in a timely fashion. We wish you the best, and Robert did a great job as well.
Thank you. He gets the ice cream.
Yes. Now we'll prepare for the second panel.
We're out here today to ensure our natural rights are respected by those who swore an oath to support, protect, and defend the rights of the people. The purpose of all interactions is to peacefully promote government accountability and transparency. Please like, share, and subscribe so this message can reach as many people as possible. I implore you to peacefully seek redress to any and all of your grievances. This is a public service.